With constructive dismissal, this is also a type of unfair dismissal. This is where you resign in response to a fundamental breach of contract. So that could be you've been demoted, you've been discriminated against at work, you have had your salary not paid. It could be a number of different ways, but it can also be a breach of what we call an implied term. And that's where you feel that the trust and confidence has gone between you and your employer, or that your employer haven't acted in good faith. Now, for constructive dismissal, you do have to resign in response, and what that means is you can't delay. If you delay for, say, more than a week, what you can find is that the employer will say you've affirmed that breach, which means you've effectively accepted it. So you have to act really quickly. You would ordinarily put a grievance in if you are trying to deal with it internally, but if you feel it has fully broken the contract of employment, you need to act promptly, and you should ordinarily resign without notice. Resigning with notice can be difficult to then argue that you've resigned in response, because if you're working the notice period, you can then be seen to be delaying. The other way that constructive dismissal can be brought about is where there's a series of smaller breaches that are taken collectively. So that might be over a period of time, you're bullied, you're harassed, you have issues around pay. There's lots of little things that are gradually breaking down that working relationship, and then there's a final straw.